Good afternoon, everyone. Thank you for joining us for today's session of our Work From Home Wednesday series for Fastcase. Today, we're going to be covering copyright of the Annotated, the Georgia versus PublicResource.org case that was just decided on by the Supreme Court. Before we get started with today's presentation, we do have a couple of really quick housekeeping announcements. The first announcement, you may have noticed that you're currently in listen-only mode. This is to cut down on the amount of background noise. However, you are more than welcome to ask questions during today's presentation. There will be a question and answer session towards the end of the presentation, but you can ask them at any point. To do so, please use the questions button on your GoToWebinar pop-up. I'll be able to see those questions and get them ready for our question and answer session. Second quick reminder, today's session is not for CLE credit. However, we will be recording today's session and it will be available for later viewing. If you are a registered attendee, you will receive it automatically via follow-up email after today's presentation. All right, so with those two quick announcements out of the way, I'd like to get us started on today's topic. Our speaker is, of course, the CEO of Fastcase, Ed Walters. Ed, would you like to take it away?
Yes, thank you, Erin. So today we're talking about the Georgia versus PublicResource.org case. And I love this title, Copyright of the Annotated. It's kind of like Dawn of the Dead or something. I imagine like these kind of zombie annotations, like reaching their hand out of the dirt or something. I should say thank you to Ken Strickland and Aaron Page who have set this presentation up today. I love these kind of webinar Wednesday programs. While we're all working from home during COVID, it's nice to kind of catch up with each other, to kind of learn more about different topics. And this is a fun way to do that. This topic is near and dear to my heart, the copyrightability of the law. So I'm Ed Walters, as Erin said. I'm the CEO of Fastcase. I'm also an adjunct professor at Georgetown Law and at Cornell Tech. I teach at Georgetown Law in the fall, where I'm teaching the law of autonomous vehicles. Cornell Tech in the spring, where in the law school, the computer science department and the business school kind of cross-listed in New York City. I teach the law of robots. I'm the author of Data-Driven Law and an editor of the Journal of Artificial Intelligence, Robotics, Artificial Intelligence and Law, or RAIL. Importantly for this topic, I'm also a board member of PublicResource.org, and I want to say that at the very top. If you are looking for objective or dispassionate commentary on this case, you might want to find on a podcast. I definitely have a dog in this fight. All right, so I just want to start by talking about the opinion itself and the case. In April, a couple of weeks ago, the Supreme Court held that public law, including annotations, is not copyrightable. And one of the most common questions that we get about this is that even a question? Like, of course the law isn't copyrightable. That's nonsense. Why are we even asking that question in the first place? So we're going to cover that today. Who cares? Like, should anyone really care about whether law is copyrightable? We're going to get that as well. How does law sort of become a code? How do you end up with codified laws? We'll talk about that a little bit as well. And then we'll talk about the procedural posture, like the case as it developed, the facts here, and how it sort of wound its way up the district court and the 11th Circuit and to the Supreme Court. Then finally, we'll talk about the Supreme Court's opinion and what that means. So that's our signposting for today. I guess I'd just like to start, if I could, with this top level question, right? What are we talking about? When we're talking about whether a state statute can be copyrightable, what is it that we're really talking about? I think when I say state statute, you might imagine like a row of books on a shelf that you pull off the shelf and kind of open, blow the dust off of it, sort of read through the statute book. How could you copyright that in the first place? Well, I think to really discuss that, we need to address how a bill becomes a code. And we all recognize Bill from Schoolhouse Rock. Bill answered the question, how a bill becomes a law, right? Bill asked this question, how do you go from a bill that's introduced on Capitol Hill until it becomes a law? But what we're going to talk about today is what happens after that, really. So we should maybe replace like Bill's sticker here with like, public law or like an act or something, right? Because we're going to start when the governor's pen finishes signing the bill into law, right? What happens after that? If you have a series of statute books, do they just take the most recent signed bill and stick it at the end and then publish a new series? No, of course not, right? If you look at state statutes or the US code for that matter, the codes of any nation in the world, right? The highlight of them is that they are codified into topical arrangement. If you want to find something in the tax law of your state, there is a tax section of the state statutes, right? So how do we get from the governor's pen stroke to that section of the codified state statutes? By the way, this is not an abstract question. This is the heart of the Georgia versus PublicResource.org case. Well, the way it happens is the governor ends up with this stack of enacted legislation, right? And in most states, this goes to the state legislature's codification council. There is an office in most state legislatures and in the US Congress, the Office of Law Revision Council at the federal level, but state codification councils who will take these enacted laws and then figure out how to put them into a body of codified law. Now, I'll be the first to acknowledge we are deep in the weeds already, right? We are looking at a bureaucrat inside of a state legislature who is trying to figure out technically how to take an enacted bill and sort of fit it into a pre-existing code. But let me tell you a little secret. The people who are doing this work are some of the most powerful people in any state government. Believe it or not, they are often writing the law. Now, you may say, like, Ed, that's nonsense. We don't elect these kind of technocrats inside of state legislatures. They couldn't possibly write the law, but I can assure you that they do. Let me give you an example. You get a tax bill, right? That tax bill is going to have effects all over the code. So this Office of Law Revision Council at the federal level or State Codification Council will have to go through this act and then figure out how to harmonize it into the existing code. They will cut it into sections and move it into that code. In some cases, they'll have to figure out how to rewrite sections of it to fit it into the code. Here's another example. You will see at the front of a lot of state statutes a definition section. These are the definitions that will fit for the whole code, right? For the whole following section. Well, when Codification Council takes an act and puts it into that section, often the act has definitions. And sometimes the definitions are not the same ones as in the title of the state code. And so this codifier will have to decide which version of the definition is going to have precedence in the final code. So this may seem like a scrivener's act. I guarantee you it is not. It is the act of lawmaking in many cases. So there's great power in the job that is done in this codification council for the legislature, taking enacted legislation, an act, and making that reflect as law in a set of codified laws, right? So this is very important. Now, you may say, gosh, Ed, that sounds really technical. How does every state have the ability to have these editors who are able to like sort of make these substantive changes to acts and put them into codes? Well, I think the answer is in many states, there are experts who do this, but in some states there aren't. And this is where we get the real traction in the Georgia versus PublicResource.org case. In some legislatures, that work is outsourced to private publishers. Now, the private publishers sign a contract with the state, and the contract will typically say something like, look, we will codify your acts. We'll have our editors do the work to put them into the code. And in exchange, you'll pay us money, but we'll reduce the amount of the fee in exchange for the exclusive franchise on the codified statute set that results. So if it is LexisNexis, then LexisNexis will do some of that codifying work for the state, but they will produce a version of the code that will have the Lexis imprimatur on it, and Lexis will have the exclusive franchise to sell that in these contracts. All right, so in many states, I think it's like 9 states, this codification work of creating law is seconded out to a private vendor who is doing that work in exchange for money or in exchange for some exclusive franchise, right? So the work tends to look like taking an app, cutting it into pieces, changing codes to reflect the words of the act, or in some cases, maybe the spirit of the act. This editorial process also has a few other steps. One of them is writing what is known in the art as catch lines. If you read any section of a code, any individual statute section, at the top of it, you'll see a headline, navigable waterways, intoxicating liquors. There will be a headline for that code section. That headline is not in the act. That is a topical sort of name for that section in the code. And in some cases, there's also annotations. Annotations here look like additional references. So in the Georgia code, for example, there are annotations that show cases that interpret a code section and tell you what courts believe that section to mean. And in the common law way, courts really add to the law. They'll take a codified section and there'll be case law interpreting it that becomes a part of that common law. And you'll find that in annotations, right? So in this case, LexisNexis was the contractor for the state code of Georgia. The Georgia Legislative Commission took that stack of acts, handed it to LexisNexis, who codified it into the official code of Georgia. They wrote catch lines at the top of the section, and then they created annotations at the bottom. They looked at cases that cited the statutes and summarized or included the most relevant paragraph of that case in the annotation to the code, okay? And then they said, we, LexisNexis, copyright the official code of Georgia annotated. We're going to give copies to the legislature and to judges in Georgia. We're going to sell those copies to law libraries and lawyers and journalists and members of the general public for hundreds of dollars and to make more money in the sale of those books. Now, the last piece of this is important. Georgia says at the end of the process, when Lexis has done this function, that the resulting set of volumes, that code, the official code of Georgia annotated, is stamped with the state's imprimatur. The state has said, this is the official code of Georgia, with the catch lines, with the annotations. Man, I sort of feel bad for you. I'm nerding out right away. I'm in the weeds, I know this, but trust me when I say every one of these facts will be important in the case. Now, I think it might be kind of a natural question here. Who cares? Why do we care if LexisNexis has some franchise on the book publishing for the Code of Georgia? I can go on the web right now and I can search for the official Code of Georgia annotated online, and I'll get the site from LexisNexis, and I can read the Georgia statutes for free. So if the Georgia code is free, why do I care if Lexis has some copyright on the books? No one's going to use the books anyway, and I can get it online. Well, there's a couple of reasons that you might care. Reason number one, what's online is not the official code of Georgia annotated. The official code of Georgia actually has this preface that says this is the only official code. If you're using something else, you are not using the official. You could have liability for not using the official code of Georgia. Number two, the online version doesn't have annotations, right? So if you want to see how courts have interpreted these statute sections, the way the official code of Georgia annotated will instruct you, you can't get that online. And number three, no one can use it. So I'll tell you a story about this. Many years ago, Fastcase got a contract with the State Bar of Georgia to provide a member benefit for every lawyer in the state. The State Bar was going to buy Fastcase and bought Fastcase for every lawyer in the state who could get cases and statutes and regs and court rules and constitutions for free. And as a part of that process, we wanted to include the official code of Georgia annotated. So we went to the web to download the official code of Georgia annotated from the state legislature's website. But on the bottom of every page was a copyright notice saying copyright LexisNexis. We contacted the state legislature and said, look, this copyright notice is probably for the Lexis web page, but in an excess of caution, we want to make sure there's nothing editorial in here. All we're getting from the legislature's website is the official code and nothing else. And the legislature told us, no, don't download the official code of Georgia annotated because LexisNexis owns it. Now, that might be an oversight by the person in that office. So we called friends at Lexis and said, hey, we just had the strangest conversation with the legislature in Georgia. They're under the mistaken impression that you own the official code of Georgia annotated. And Lexis said, no, we do own the official code of Georgia annotated. And so we said, well, how can that be? It's written by legislators. It's prepared by the legislature of Georgia. Do you claim copyright in what they wrote? And Lexis said, no, but the catch lines, the titles at the top of each section, we write, and we claim copyright in that. The annotations we prepare, we can't claim copyright in that also. And so we at Fastcase said, we'd love to license it from you, and Lexis declined to license it to us. So why do we care? Suddenly, Fastcase can't include the code of Georgia in a free benefit to lawyers in the state. Now, what we did was we rewrote all the catch lines and wrote our own annotations for the code. So the parts that were copyrighted, we didn't include in that set. But the consequence of that is that lawyers in Georgia were using an unofficial code when they were using Fastcase. Anybody who wants to innovate with public law can't do it because the official code of Georgia with annotations, with catch lines, was copyrighted by LexisNexis. So the result is our law, paid for at taxpayer expense, created by our representatives in the legislature, is copyrighted. And we, in some sense, can't use it. Even today, if you want to go on some of these websites, the private publisher websites will tell you that there is a terms of service. If you want to use these codes, you have to agree to a contract that many think is enforceable. That says that you can't use it for commercial purposes. So copyright notwithstanding, they're trying to create a terms of service restriction on it. All right, so it is into this state of affairs that PublicResource.org got involved with the official code of Georgia annotated. Many of you know PublicResource.org. It is helmed by Carl Malamud, who has been described colorfully as a rogue archivist. I sort of like that designation for Carl because what he is trying to do is preserve the commons. He is trying to take things that are public and ephemeral and preserve them for the ages. And law is a particular source of concern for Carl and PublicResource.org. So Carl said, look, if the official code of Georgia annotated is the official code of Georgia, the one and only source of statutory law for the citizens of Georgia, then it is explicitly in the public domain. It is owned by the people. And so Carl bought a copy, a paper copy of the Official Code of Georgia Annotated. He ran it through a high throughput scanner and created very useful PDFs of the Official Code of Georgia Annotated. And then, not in the dead of night, not in a sneaky transaction, in full daylight, in the full light of day, said, I take this public law and submit it to the public. He posted it online, but he also sent copies of it on USB sticks to the Georgia legislature and said, I'm giving you this PDF copy of the Official Code of Georgia Annotated. It is in the public domain, and I am publishing it. I want you to know that I'm publishing it. I want the whole world to know where I got this from and what I'm doing with it, with the purpose of making this public domain law available to the public in the public domain, not behind a paywall, not locked up in a book, not behind terms of service, available for anyone, anywhere in PDF format, including the catch lines, including the annotations, including everything in the Official Code of Georgia Annotated. So the state of Georgia sued PublicResource.org, brought an action against them for copyright infringement on behalf of the state, and I would suppose on behalf of its licensee, LexisNexis, in the Federal District Court, the Northern District of Georgia, the Atlanta District Court. So that court held that the annotations created by LexisNexis on behalf of the state were copyrighted, and required the PublicResource.org take the Official Code of Georgia offline immediately. And PublicResource.org, being a good corporate citizen, being a good, I shouldn't say corporate, but a good nonprofit citizen, listened to the court's mandate. It immediately took the Official Code of Georgia Annotated offline, but appealed to the US Court of Appeals to the 11th Circuit. And the 11th Circuit said, no, this is not copyrightable. State statute's not copyrightable. This is an edict of government. This is the one and only Official Code of Georgia. Therefore, it is not copyrightable. So PublicResource.org put the Official Code of Georgia back online, and the state of Georgia appealed the 11th Circuit opinion to the US Supreme Court. Now, you should say, I should say, it's a long shot, right? The Supreme Court hears 80 cases a year out of the tens of thousands that are decided by state Supreme Courts and circuit courts of appeal around the country. So it was kind of a long shot. But what happened next, I think, is fascinating. So Georgia appealed the loss to the US Supreme Court, and PublicResource.org also did. This is incredible. They won the case, right? PublicResource.org won in the 11th Circuit and said, that's fine. This is great that it's binding law in the 11th Circuit. We also are going to apply for certiorari before the US Supreme Court because we would like a statement from the US Supreme Court saying what everyone knows already, that private companies can't have copyright in public law. So both the losing side and the winning side in Georgia versus PublicResource.org in the 11th Circuit applied for certiorari to the US Supreme Court, asking the Supreme Court to hear the case. And I have to say, it's somewhat unusual. The Supreme Court granted cert. This is a very, less than 1% of cases are granted cert for a decision in the US Supreme Court, but Georgia versus PublicResource.org did get cert. Now, look, I should say there is a kind of a long legislative backdrop. There is a long history of copyright cases that govern what's going on here. I'm not going to go super deep into it today, but I will sort of refer you to an article that I wrote on Medium that originally was on Vox Populi, Cornell's Legal Information Institute, called Tear Down This Paywall, Private Ownership of Public Law and How to Stop It. In that article, I go into the full history of copyright dealing with public law, starting with judicial opinions in cases in the 1800s. In fact, the very first copyright case that the US Supreme Court heard, Wheaton v. Peters, deals with the copyrightability of US Supreme Court opinions. Some of the earliest reporters of Supreme Court opinions were involved in copyright litigation over this exact issue. And so I sort of cover the legal groundwork, the case law, and the evolution of the public edicts doctrine in that article. Even I am not nerdy enough to do that in this kind of webinar format. But I think it's maybe worthwhile just to say that it is extraordinary for both the winning party and losing party to appeal to the US Supreme Court. It is extraordinary to have cert granted in a case like this. So here we are. We are now going to argue this public law case before the US Supreme Court. At stake is really nothing less than whether public law can be copyrighted. Right? I mean, the court has the opportunity here to make the 11th Circuit opinion that statutes can't be copyrighted nationally, or to say the district court actually had this right. Georgia has the right to make public law copyrightable, and I suppose create a fertile ground for takedown notices of state codes in services like Fastcase or Bloomberg Law or Westlaw or LexisNexis, I suppose, in some circumstances. There was a lot at stake in this case. Now, I've already sort of said that PublicResource.org won this case in April, so there's not a whole lot of kind of dramatic tension here. We already know at this point, this is July 8th, who won the case. I want to point out some extraordinary things about this case, though. It's already extraordinary in many ways. The biggest copyright case in the country for years, maybe for a decade. The first thing that I think is really interesting about this case is that it was authored by the Chief Justice. This is the Chief Justice of the US Supreme Court. Whenever the chief is in the majority, he assigns the author of the case. So here, it is a 5-4 decision. The Chief Justice is in the majority and could assign it to anyone. Copyright is not the sexiest area of law. Ordinarily, for these cases that are procedural or technical, the chief might refer it out to a more junior justice. But the chief said, this is actually important enough that I want to write the opinion. I am picking this one. I am calling it out. Okay. Second, the language that the court uses in this case could have been pretty narrow. The court could have said, look, in these limited circumstances, based on what LexisNexis does in this case, based on the language in the contract with the Georgia legislature, we hold that these specific annotations are not copyrightable. But that's not what he does. The chief actually takes this opportunity to really expound on the public edicts doctrine, right? And I've called out the section here, but I just want to read it out. I can't, kind of speak with the authority of the chief, but I want to emphasize how sweeping this decision is. The court discusses all of the cases holding that judicial opinions don't have copyright, whether they're from state or federal courts, right? And we already know that works of the federal government don't have copyright protection. That's explicit in the Copyright Act and the US Code. But so the chief builds on all of that and says, if judges acting as judges cannot be authors because of their authority to make and interpret the law, it follows that legislators acting as legislators cannot be either. It is the lawmaking function, I'm out of the quote now, it is the lawmaking function that matters. The court continues, courts have thus long understood the government edicts doctrine to apply to legislative materials. And he's quoting the Nash case and says that statutes stand on substantially the same footing as judicial opinions. And Howell versus Miller, looking at statutes and supplementary materials under the Banks and Callahan decisions. The court continues, moreover, just as the doctrine applies to whatever work judges perform in their capacity as judges, it applies to whatever work legislators perform in their capacity as legislators. That, of course, includes final legislation, but it also includes explanatory and procedural materials legislators create in the discharge of their legislative duties. In the same way that judges cannot be the authors of their headnotes and syllabi, legislators cannot be the authors of, for example, their floor statements, committee reports, and proposed bills. These materials are part of the whole work done by legislators, so they must be free for publication to all. Under our precedent, therefore, copyright does not vest in works that are, 1, created by judges and legislatures, 2, in the course of their legislative duties. This is an amazing, sweeping statement. The court here is expounding a public edicts doctrine that says that anytime judges, anytime legislators are acting in their lawmaking capacity, whatever they write is not copyrightable. Okay? This might be true in the federal government already under the statute, under the Copyright Act, but the court here is saying it is also true for states, right? A big question in the oral argument for this case was, are annotations binding law? There's some part of the court that believed that if they weren't binding law, then they should be copyrighted. They shouldn't be understood to be law in the binding sense. And if they're not binding law, that part of the court believed, then you could copyright. But the chief here says, no, no, no. When you are acting in your lawmaking capacity, it doesn't matter if it's binding or non-binding. Everything legislators, everything judges do is not copyrightable. For example, a dissenting opinion in a judicial opinion isn't binding law, but that doesn't make it copyrightable. It's not like Justice Thomas could claim a copyright on a dissenting opinion in the US Supreme Court case. And similarly here, the fact that annotations or catch lines are not binding law doesn't matter at all. The court says, if you're acting in your legislative capacity, the things that you produce are not copyrightable. The next part I think is extraordinary, which is that the court holds this is an agency relationship. When a legislature hires a private publisher to create these public law materials, they're just an agent, right? And that agent can't have any more copyrightability than the principal can, which makes sense if you think about it, right? It would be weird if you said that the state can't copyright things. It's legislative work, but that it could bypass that prohibition altogether by just hiring an outside contractor to do it for them, thus making it copyrightable. That seems kind of crazy. It is natural to think then, if the principal, the state legislature, can't have copyright on the legislative work of the legislature, then they can't somehow make it copyrightable by seconding that function out to a private vendor or a private contractor. The last part of this, I think, is the most majestic, if you will. It's beautiful in a sense. The public edicts doctrine, as explained by the Chief Justice, is about authorship. The Constitution, Article 1, Section 8, grants to authors these copyrights of limited duration. And the question is, who can be an author? So there's all of these great cases like Naruto versus Slater, the monkey selfie case, where a Preston Macaca presses the shutter on a camera and takes a picture of himself. And there's this case asking whether Naruto has the copyright on that selfie. And it centers on who is the author of that photograph. Do you have to be a human to be an author? And under the Public Edicts Doctrine, the court says legislators, judges, people in public service who are acting on behalf of the people are nothing more than the agents of the people, which means that acting in their official capacity, when acting as a legislator, legislators are doing the work of the people, which means that the people are the author of bills. They are the authors of statutes, and they are understood to own them. That copyright is held in the public domain by the public for the public and can't be cordoned off by legislators, can't be cordoned off by private publishers acting on behalf of legislators. In their official capacity, when they're writing as lawmakers, judges and legislators are agents of the people who are the constructive authors of these legislative works. It's pretty striking, and it's an amazing, beautiful formulation. This is something that many advocates have called for. It wasn't the ground of the reasoning of the 11th Circuit, but the court has gone beyond the kind of narrow reasoning of the 11th Circuit and explained the Public Edicts Doctrine in this way. Okay, there's a few other things I want to note about this. This is a very interesting coalition of the US Supreme Court. In a 5-4 opinion, a lot of times people will look at, whether judges are conservative or liberal or who appointed them, and who splits from whom to form these coalitions, whether it's along party lines or something else. It's fascinating that the Public Edicts Doctrine doesn't seem to have an ideological bent. The court in this case, the coalition was the Chief Justice, Justice Roberts, joined by Justice Kagan, Justice Gorsuch, Justice Sotomayor, and Justice Kavanaugh. I haven't looked at this kind of logistically, but that might be the first time these 5 justices have constituted the 5-justice majority in a US Supreme Court case. It is also the 5 youngest justices of the US Supreme Court. So maybe there's a generational shift here. Maybe it's the young guns in the court who are kind of rooting for public ownership of public law. But a fascinating, sweeping opinion. And I think you have to say, well, I will say it, we should recognize the courage of PublicResource.org in this case. When you publish the Official Code of Georgia Annotated online in its entirety, there is a high risk that you are going to be sued. That didn't deter them, right? When you lose in the district court, it is an uphill climb to win in the Court of Appeals. It's expensive, it's time consuming, and the risk is that you have a much broader precedent working against public law. But PublicResource.org nevertheless had the courage of their convictions to pursue that appeal. And then in the ultimate show of conviction, to appeal their victory in the 11th Circuit to the US Supreme Court. And this is the result. It is because of that courage that we get this soaring opinion on the Public Edicts Doctrine from the Chief Justice of the US Supreme Court. All right, so where do we go from here? I'll just say in the kind of aftermath of Georgia versus PublicResource.org, there are some obvious frontiers. A question that I have is, if this doctrine applies to judges acting in their judicial capacity, if it applies to legislators in their legislative capacity, isn't it natural to think that it would apply to agency regulators when writing rules in their legislative capacity? Or I should say regulatory capacity, wouldn't agency regulators be a next natural frontier? Another one is standards incorporated by reference. When a legislative body incorporates standards into regulations or laws, does that pass those standards into the public domain under the same reasoning of Georgia versus PublicResource.org? This is actually a case right now that PublicResource.org is engaged in. I think we'll soon have some answers to that. And then last, I would just say, it raises an important question about the enforceability of terms of service in public law. If you are the California legislature and you are publishing California judicial opinions, is it permissible to put a terms of service in front of them and say you may only use these for non-commercial purposes? And by clicking I agree, you are entering a binding contract with us, granting us copyright-like rights in this private click-wrap contract. So I would say these are three frontiers. The Supreme Court's soaring opinion in Georgia versus PublicResource.org seems to point to the idea that none of those three things is copyrightable. All of them would be considered to be public law making by people in their official capacity, and therefore rendering the output to be uncopyrightable. Should we care about this? One of the arguments before the US Supreme Court was that if we deny private publishers the ability to copyright the output of their work, they will simply charge states more money, and states won't be able to afford the work of codifying their codes. Isn't this a terrible outcome that we'll no longer have codes? Well, I say no, and I think that's kind of a straw man argument. First of all, lots of states do this, not just big states. States of all sizes and of all means are able to codify their laws without the use of outside vendors. Is it more expensive? Yes. So is governing, so is lawmaking, so are judges and everything else in the world. It might require a reallocation of funds. It might cost more money. On the other hand, it might not. States should be the publishers of their own law. They should have this function, and everything can't be outsourced. Some things are too important to outsource. And so the fact that we're bringing this function back within the kind of ambit of state legislatures, I'm not too concerned about. Second, should we be worried about private publishers? Private publishers are companies that are making good products. We like those products. Is this going to be the end of those? I say no way. If you look at other states, our experience in those states is that the states can put out an official code, maybe without annotations, take out the most expensive parts of it, right? And then any private publisher, Lexis, Westlaw, Fastcase, can take the official code and build all kinds of cool stuff with it. Like in the Fastcase legal research application, we automatically annotate the codes, right? We go through judicial opinions, we find citations to the statutes, and then we flip the index. So when you're looking at the statute, you can see all of the cases that cite it. You can pull out the paragraph from the case that cites it and see what the court is saying about it. We're able to do that because the law is public. We can take that public law and we can do all kinds of cool stuff with it in Fastcase because it is public. And our derivative work, our transformative use, is something that we can sell subscriptions to. Are we trying to claim the one and only official code of Georgia? No way. Everybody should have access to that. But the stuff that we build on top of it, I think it's fair to say we could copyright or sell subscriptions to or anything else. And importantly, the court here stops short of saying anything involving the law is uncopyrightable. They are recognizing that publishers could take the official code and add to it, create derivative works, create something new in copyright that is especially valuable. If anything, this should lead to a really interesting era of innovation where people take these public law sets and create interesting new products from them. This is the model. So this happened in Washington, DC a few years ago. The counsel of the DC Council, Dave Zvenich, said in negotiations with a publisher, you can publish the DC code, but before you create your set, we want an unannotated version that we are going to deem official, and we're going to publish online for free so that anyone can use it. And I think the DC model is a good model for the whole country, including Georgia. Take the unannotated version of the codified statutes, make them public, declare them in the public domain, and then allow LexisNexis to create its Code of Georgia annotated, not the official Code of Georgia annotated, because the official code is unannotated, but the Lexis version of it with the Lexis annotations that I'm sure have great value, and the market will prove or not whether it's valuable enough to charge $400 for that set, right? But in that way, you'll have interesting innovation coming out of publishers and public law the public has access to in exactly the way the people of the state of Georgia and all over the United States, and dare I say it, all over the world, expect and deserve. All right, my 45-minute monologue is now up. It's even run a minute long. I will say thank you for listening to my nerdy diatribe about the copyright, public law, and the public edicts doctrine. Aaron, if you would like to maybe moderate, I'll be happy to take a few questions from the audience.
Be delighted to, Ed. So we do have a couple of questions, at least one of which I'm pretty sure you Ed answered with that coda there. So I'll move to the next question down the list, which was, do you think that this decision or related decisions will start pushing states to make more materials available online, or do you think this will freeze or inhibit that tendency? The examples that were given were the Arizona regulations being only available in print format and other materials of that nature.
Well, I hope, it seems to me like the trend over the last 20 years, in the time that I've been working at Fastcase, has been more openness, more transparency, and more public publication. The tools to move these materials online and to host them are cheaper than ever. The ability to index and search them, there are great open source tools that do this right off the shelf. So it's easier than ever for states to do this without great expense to them. So I expect to see a lot more of that. The reason this case was so important is that we are on a 20-year streak where the trend has been towards more openness. And yet, near the end of this 20-year period, you have these hard lines being drawn by publishers who are trying to copyright public law. We are taking what is one of the last walled gardens of the internet, the law, public domain law, and I think accelerating the trend of the last 20 years and not allowing anybody to stop that train. So that's my aspiration. And I will just say this, I have pledged this before, but I'll pledge it right here as well. If there's any state who's having trouble with this, if you feel like you can't afford it, if you feel like you don't know how to host these laws online or make them searchable without giving away some of the store to a private publisher, we'll help. Our team at Fastcase would be delighted to help you put Arizona regs online for free in the public domain. We'll do it at no charge. We'll be glad to tell you what we've learned. We'll be glad to help you find the right tools to do it. And I know that we're not alone. There is a large coalition of people who are working to preserve and protect public domain law. PublicResource.org, Cornell's Legal Information Institute, the Free Law Project and Court Listener, the CAP Project, Case Law Access Project at Harvard, the folks at Justia. I don't want to leave anybody out. There are lots of groups that are really doing great work to put public law in the public domain. This coalition of people and companies would be delighted to help you to host those online and to do it at a very, very low cost, maybe even no cost to you. So if you think it's prohibitive, if you think you can't do it, please reach out to us. You saw my Twitter handle at the front. It's at EJ Walters. You can send me a direct message. My DMs are open. I'll be happy to point you in the right direction, put together a tiger team of ninja nerds who can help put your public law online. We would be delighted to do that.
Fantastic. All right, next question. Can you comment regarding the possibility of copyright on an attorney's pleadings or motions, documents that have been filed with the court? Should they be considered to be public domain, or are they capable of copyright?
There's a great opinion on this, actually. They've been held by a court to be in the public domain, and that libraries of them are transformative uses and not copyrighted. When you submit them to the court, they are in the public domain.
Fantastic. The next question is regarding the application of this decision. Is it going to apply retroactively to historical statutes? And if so, is Fastcase planning on expanding its historical state statutes?
Yes, it applies retroactively. It would be weird if you said that everything was copyrightable up to this decision. So I think that the idea is that nothing in the state statute realm, at least the official realm, is copyrightable ever. And I would say we are always expanding those libraries. For us, the issue is really more about what's available online and less, the availability of copyright. We've always sort of held that these materials are uncopyrightable. Now, we may have had to work around some of the copyright, but you'll see more and more of these materials online. One good example of that, the Code of Georgia on Fastcase now includes the correct and official catch lines. We originally wrote 30,000 catch lines for the Georgia Code to avoid the claim of copyright in LexisNexis. Now it's a straight line. We just include the official catch lines from the Georgia Code. I would say watch for annotations next. And our commitment is that public law should be usable by Fastcase, should be available in Fastcase. And so we'll continue to be very ambitious about putting those online for people.
Great. The next question is, can you speak a little bit to the dissent from this particular decision? Why wasn't the case unanimous, and is there any particular theme in the dissent?
Well, one of the themes was, what is binding law? And the idea is that there is kind of a due process reason for not making it copyrightable. If people are bound by the law, then due process requires that law be available to them to read. And so copyright would be inconsistent with this due process argument. And there's a rationale for that. I do think that there are due process implications, but that is a minor subset of the public edicts doctrine. The public edicts doctrine is much more expansive, saying that the author of legislative works written by legislators in their legislative capacity, the author is the people. By the way, I should say, I didn't say this before, it doesn't conscript legislators in their non-legislative work. If a US senator wanted to write a book, or if the Speaker of the House of the Georgia House of Representatives decided to write children's books, of course those would be copyrightable because it's not them acting in their legislative capacity. But when they act as an agent of the people are the author.
Excellent. So what would you say is the biggest argument against the public edicts doctrine, or against that the dissent highlighted in this particular argument?
Well, I won't go too much into the dissent, but I will say that the biggest argument is probably a policy argument. The states have said we can't afford to do this without the good graces of private publishers. And the consequence of this, of holding the public edicts doctrine in this expansive way, is going to be that we're not going to have these kinds of materials created by states. To which I say, watch what happens. I think that's the biggest argument against an expansive reading of the public edicts doctrine. But I'll just tell you, if you come back 5 years from now, there is no way that there are fewer sets of public laws, fewer statute sets, fewer regulation sets. There'll be many more, and they'll be much better. Gotta happen.
Well, we are running up against the hour, so I'm going to do one last question, and then I have one announcement at the end. Please stay for it. It's important. Last question that we seem to have here is, do you think, or in addition to expanding the policy regarding public edicts, what other directions do you see lawsuits either from PublicResource.org or other entities that are advocating for free law or for free public law. What other major areas do you see being a concern or something that needs to be litigated over?
Yeah, well, so there are parallel cases in Canada. My friend Kim Nair has written about these and spoken about them. She's the law librarian for Cornell Law School and herself a Canadian. So there are parallel cases going on in Canada right now. And then I would say the incorporated by reference or standards cases are really next up on deck. They're sort of in the batting circle, if you will. PublicResource.org is litigating this right now, the incorporated by reference or standards issue, whether a standards making body who promulgates model codes with the intention that they are included into state statute collections or municipal regulations. The question is when they are sort of added to those codes and stamped with the imprimatur of being the official law of a jurisdiction, do they then pass into the public domain? When the standards body goes to sell them to the next jurisdiction, can the jurisdiction say, no thanks, we'll just copy it and paste it from Texas or Georgia or California? When that probably otherwise copyrightable standards work is included in an official code and stamped as official, does it pass into the public domain? And I think that the logic of Georgia versus PublicResource.org would seem to say yes. Once it becomes official, it passes into the public domain. It is no longer a copyrightable work. It is public in the truest sense. And I personally would have a hard time seeing why a jurisdiction couldn't copy the Texas statutes or the California statutes and use that as a model for their own statutes, regardless of the source of it, right? You don't need to look back to what lobbyist wrote the text of the bill. You merely need to say it was passed, made official, and then passed into the public domain. So I think that's one of the interesting frontiers. Canada is a very interesting case. I think incorporated by reference suits are also very interesting as well.
Fantastic. All right, so one correction from earlier. I had mentioned that today's session was not approved for CLE credit. I stand corrected. It is approved for CLE credit in Iowa, thanks to a audience member. So the number for CLE credit in Iowa is 351035. Again, for CLE credit in Iowa, the number is 351035.
Man, Aaron, I know I'm speaking for you when I say we wish we could make them CLE approved in all the states. It's a really hard process to go through the kind of bureaucratic process in every state. But thank you to the Iowa State Bar Association for approving that one for credit.
We appreciate it very much. And I'd like to thank everyone for joining us for today's session, Georgia versus PublicResource.org, copyright of the Annotated. I hope that everyone will join us for next week's session. We're going to be doing a roundtable on some other Supreme Court decisions. They should be very interesting, so we hope that you'll join us for that session as well. And please do check your email after today's session. We will be sending out an email with the link to today's recording, as well as the information about the case. So again, thank you everyone for joining us for today's session, and we hope that you have a great afternoon.